Judge Gideon. I come before you today, not for the first time, to say that I am not guilty of the charges and that the prosecution has not proved my guilt. I was doing some research to prepare this argument of guilt and innocence, and also with regard to the international laws that we are calling on you and on the people at the base to attend to. And so I'm going to speak of that. I'll preface my remarks by saying that we're ever grateful for the right and privilege given to us by the First Amendment of the United States Constitution, which says that Congress shall make no law abridging the freedom of speech or the right of people to assemble and peaceably and to petition the government for redress of grievance. We would not be here today if this were not the law of the land. I will argue that I went to Hancock Base on the 25th of October in 2012, that as far as I know, we all assembled at Hancock Base on October 25th of 2012 to exercise our right and privilege of free speech to ask our government for redress of grievance, specifically to uphold the international laws that prohibit wars of aggression, targeted assassination, and the reckless endangerment of civilian populations around the world. You have heard testimony that weaponized drones, including those flown from Hancock Air National Guard Base, are on the front line of illegal wars in Afghanistan, Pakistan, Yemen, Somalia, and other countries around the world. You have heard testimony that armed drones threaten civilian populations in these countries and, contrary to government assertions, kill indiscriminately, leaving a trail of dead civilians in their wake. Often, even the oft-affirmed militant target is a civilian in many cases, perhaps in every case, depending on whether American combatants can be said to be engaged in a legal war. According to customary international law and numerous treaties that I will now elaborate, these wars of aggression are illegal. Therefore, my presence at Hancock Air National Guard Base is justified under New York State Penal Law 3505, subsection 1, unless otherwise limited by ensuing provisions of this article defining justifiable use of physical force. Conduct which would otherwise constitute an offense is justifiable and not criminal when, number one, such conduct is required or authorized by a law. In light of Article 6 of the United States Constitution, which says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding." We turn to the following passages from the Nuremberg judgment, which was designated as a federal rules decision in the 50s, thereby incorporated into United States law as well as the United States Army Field Manual. On page 19 of my copy, under the common plan or conspiracy and aggressive war, the esteemed justices of the Nuremberg court say, "War is essentially an evil thing. Its consequences are not confined to the belligerent states alone, but affect the whole world. To initiate a war of aggression, therefore, is not only an international crime, it is a supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole. On page 42, under violations of international treaties, and I'll tell you just so you know that what I did is I copied it off the internet into a PDF so I could read it more easily, and that's where my pages are coming from. I just plopped it into a document, and the pages were numbered. So anyway, on page 42, under violations of international treaties, the court continues in the same vein. It says that the waging of an aggressive war is a crime, regardless of whether any signed treaty has been violated. The Charter defines as a crime the planning or waging of war that is a war of aggression or a war in violation of international treaties. This makes it unnecessary to discuss the subject in further detail, or even to consider at any length the extent to which these aggressive wars were also wars in violation of international treaties, agreements, or assurances. In other words, since we agreed that prosecuting a war of aggression is a crime, we do not need any further treaties to justify our verdict. On pages 44 to 47 of the Nuremberg judgment, under the law of the Charter, the Nuremberg judges state, the Charter is not an arbitrary exercise of power on the part of the victorious nations, but in the view of this tribunal, as will be shown, it is an expression of international law, existing at the time of its creation, and to that extent it is itself a contribution to international law. The United States must have agreed with this at the time because the judgment was admitted to U.S. law as a federal rules decision. They go on to say that it is a matter of justice that a criminal act is understood with reference to a law. So they proceed to name the treaties on which they have based their judgment. First and foremost is the Kellogg-Briand Treaty, also called the Pact of Paris, because the United States and France were the makers of this treaty and the Charter signatories. This view is strongly reinforced by a consideration of the state of international law in 1939. And I will say that much of this hasn't changed in 2014. So as far as aggressive war is concerned, the General Treaty for the Renunciation of War of August 27, 1928, more generally known as the Pact of Paris or the Kellogg-Briand Pact, was binding on 63 nations at the outbreak of war in 1939. The first two articles of Kellogg-Briand are as follows. Article 1. The high contracting parties solemnly declare in the names of their respective peoples that they condemn recourse to war for the solution of international controversies and renounce it as an instrument of national policy in their relations to one another. Article 2. The high contracting parties agree that the settlement or solution of all disputes or conflicts of whatever nature, of whatever origin they may be, which may arise among them, shall never be sought except by specific means. In case we don't take this seriously, the Nuremberg judges go on to quote Henry L. Stimson, U.S. Secretary of State in 1932 as follows. War between nations was renounced by the signatories of the Kellogg-Briand Treaty. This means that it has become throughout practically the entire world an illegal thing. Hereafter, when nations engage in armed conflict, either one or both of them must be termed violators of this general treaty law. We denounce them as lawbreakers. I have been told that the Kellogg-Briand Treaty is obsolete and irrelevant. No one pays any attention to it. However, the United States has not withdrawn her signature from Kellogg-Briand as she has, for instance, from the International Criminal Court of Justice. Kellogg-Briand is not only a basis for the Nuremberg judgment, which is accepted as a federal rules decision, but is a direct creation of U.S. diplomacy, of which the United States is a charter signatory. Perhaps it should be taken more seriously. Clearly, Kellogg-Briand does not codify particular penalties for particular variants or degrees of the crime of aggressive war. The Nuremberg judges respond to this concern as follows. But it is argued that the pact does not expressly enact that such wars are crimes or set up courts to try those who make such wars. In interpreting the words of the pact, it must be remembered that international law is not the product of a legislature, and that such international agreements as the Pact of Paris have to deal with general principles of law and not with administrative matters of procedure. The law of war is to be found not only in treaties, but in the customs and practices of states, which gradually obtained universal recognition and from the general principles of justice applied by jurists and practiced by military courts. Here we have an argument that international law is a foundation of global justice and should be enforced through understandings and procedures defined by customary law, which has evolved through the consensus of nations over a period of centuries. And I might add that the Geneva Protocols, which we had spoken of on occasion, are an expression of that customary law. Armed drones, which are currently a critical tactical method in the support of our many wars of aggression, are engaged in the commission of crimes against peace, insofar as they facilitate illegal wars and war crimes, and war crimes and crimes against humanity, insofar as they facilitate indiscriminate killing of civilians and targeted assassinations, which were made illegal under U.S. law during the course of my lifetime. It is a matter of particular concern that United States officials are attempting to change customary international law to their advantage by changing the facts on the ground through the introduction of new technologies and social classifications. Terrorists and terrorism supposedly represent a class of individuals who perpetuate a condition not anticipated by customary international law nor standing treaties. However, the United States' duplicity in both fighting terrorists and supporting the same individuals under a different rubric shows that this is not the case. The use of new technologies, for instance armed drones, to terrorize civilians while supposedly hunting so-called terrorists is frivolous, hypocritical, and completely illegal. Terrorists and the armed drones that hunt them are social and technical constructs designed to disrupt international law and the social structures on which it is founded. Drones are asserted to be a device that is not constrained by customary international law as we have understood it in the past, and this is clear from the statements by the United Nations Rapporteur and also the NGOs reports that came out over the last year from Amnesty International, who spoke about Pakistan, and from Human Rights Watch, which looked at some cases in Yemen. They claim that drones are so advanced as to require new laws for new situations. They say drones can fly at great heights out of reach of retaliation by populations without air power. Since drones aren't manned, if someone did retaliate, no human would be harmed. Since a drone can be piloted from a faraway location that is not in the clear zone of war, then the pilots are not at risk and they have not violated any boundaries. Drones are able to discriminate their targets more effectively than other delivery systems for missiles is another thing they say, which I would say may be true, but is not the critical issue. To me, the above list of special features can be subsumed under a single classification: impunity. The latter point, in particular, has clearly proven not to be the case. It takes more than a stable image from 2 miles away to provide meaningful clues to an operator 10,000 miles away of whom they are looking at and what they are doing. Drones are used to conduct illegal wars invisibly. Even so, new laws aren't necessary to constrain armed drones. What is necessary is that their owners and users be called to obey the existing laws. In fact, international law has addressed this very situation more than 100 years ago. Initially, the Martens Clause, as it is called, was introduced into the prologue of the Hague Convention number 2 in 1899. Later, the substance was incorporated into the Hague Convention 4 in 1907. The Martens Clause states, until a more complete code of the laws of war is issued, the high contracting parties think it right to declare that in cases not included in the regulations adopted by them, populations and belligerents, we would say civilians and combatants, remain under the protection and empire of the principles of international law as they result from the usages established between civilized nations, from the laws of humanity and the requirements of public conscience. This is a pretty heavy phrase. Someone I read this to earlier said, it's beautiful language, but what does it mean? But I think it's pretty clear that they're saying in this beautiful language that the laws should not be changed to accommodate brute force events that violate the structures that exist, but instead that the parties involved should be restrained by the current law, and that if some new law can be developed through the consensus of nations, then they can be expanded into that legal space. But until that legal space exists, that even new and powerful weapons are required to stay within the constraints of the old rules. In conclusion, Your Honor, I want to relate this to something that I sadly have to deal with in my home. We cannot ignore the fact that these laws are often broken, often restated in new language over and over throughout the 20th century, I'd say. It seems to me that war is much like an addiction. It's deadly and it's very difficult to end. We vow to quit, then fail and recover and relapse again and again. This does not mean that we should cease trying. Every treaty and promise to repudiate the deadly violence of war and restrain the instruments that make it easy for us to prosecute those wars must be held up and honored over and over again until justice prevails and we are at last free to live as civilized human beings in peace and security with other individuals and other nations. That is why I was at Hancock Base on October 25th, 2012, and that is why I'm here speaking to you today. I'm not asking you, Judge Gideon, to try defendants under these laws as the Nuremberg judges were required to do. That's not your job. What I am asking is that you acknowledge our obligations under these laws, along with my obligation and privilege to uphold them under the Constitution, and acquit me and my companions of the current charges under Penal Code 3505, which says that we must justify an act that would otherwise constitute an offense when it is authorized by a law or a judicial decree. And I thank you very much for giving me the opportunity to make this statement, and that I hope that you will respond to it as asked. Thank you.
Thank you.